Back to Law News Network, everybody. I'm Jesse Weber. You were watching the prosecution's opening arguments in the Adam Matos case out of Florida, but it's not that case only out of Florida I want to discuss right now. I also want to talk about the verdict in the Luis Toledo case out of Florida. And joining me now is criminal defense attorney and former prosecutor LaDawn Jones. LaDawn, thanks for joining us here again on Law News Network.
Thank you for having me back.
Let's start with Toledo. Okay, so I want to try and make sense of this. Florida initially, had a law that said you only need a majority of the jurors to vote in favor of the death penalty. They changed that law, and now you need a unanimous jury verdict. So we saw in the Toledo case, 10 jurors wanted to sentence him to death, 2 didn't. I mean, if this was a few years ago, he could be facing the death penalty.
That's correct. So Florida has had a few changes in their execution laws. There was a time just a couple of years ago where a judge can come in, whether the verdict was unanimous or not, and determine that the death penalty should be entered. More recently, they changed it to require only a jury making that decision, and now finally it has to be a unanimous verdict as of 2016 in order for a jury to determine that execution is appropriate. You know, it is already difficult in a jury trial to find guilt or innocence unanimously, but then what comes into play when determining the death penalty is a juror's own personal feelings regarding the death penalty. And although during voir dire, many times that is kind of parsed out to determine if someone could if they had an issue with sentencing someone to death, it makes it far more unique in these scenarios, whereas in any other case, the judge determines the sentence.
LaDawn, you've hit on the point I really want to address right now, okay? So you have to imagine they picked jurors that didn't feel that they would be biased by the death penalty, felt that they could elect to choose the death penalty. And I spoke to different lawyers on this case about what they thought, and most of them said that if you want to find a death penalty case, this is a strong death penalty case, because these jurors, they found him guilty of first-degree murder of these young, beautiful children, these defenseless children. So, for the average viewer, you don't understand how to make sense of it. How did these jurors not convict him to the death penalty? But is it the idea that, okay, you have these aggravating factors, right? And this aggravating factor that Mr. Toledo killed these 2 children because they were witnesses, maybe that's where the jurors just couldn't sink their teeth into. What do you make of that?
So the main issue that we put before a jury is guilt or innocence. And any rational person, no matter what their feelings may be regarding crime, can look and say, well, the state has proven their case. They've laid out all the factors, and I feel that the evidence shows this person is guilty. But when you talk about the death penalty, I think it is much harder for the average person to just look at mitigating factors versus aggravating factors. I really believe that in many cases, a person's independent feelings about whether or not a person should be sentenced to death, whether or not the death penalty is appropriate, is one of those things that just going to always be difficult to get over unless the crime is so truly heinous.
You know, it's interesting. The idea, I think what you're saying is, so if you're sitting on that jury pool, and we know that Mr. Toledo, when that verdict came down of him being guilty on all 4 counts, so first-degree murder, second-degree murder, and then tampering with evidence, he said to the judge, just sentence me to death right now. Just sentence me to death right now. Obviously, he changed his mind and tried to fight it out, but the idea that this is a 35-year-old guy would be spending the rest of his life in prison, the family members feel that that's justice. They feel that this guy's going to rot away in a cell for the rest of his life. So I wonder how much that impacts jurors in saying, we think that's the right punishment for this guy.
Absolutely. You hear jurors and American citizens say that all the time, that it is for the criminal justice system, being imprisoned is a far worse penalty than being put to death. A death, you don't have to deal with the consequences of your actions. But then there are others who say that it's unfair that a person will still be able to see family and friends, to be able to visit them, be able to laugh and see, and which is why they are in support of the death penalty.
Just let's make sense one more procedural issue in this case, because I do want to turn over to Adam Matos before we start our live coverage. The judge is going to have a sentencing hearing on January 19th. We also expect him to talk about what the proper sentence would be for the death of Yesenia Suarez, his killing of Yesenia Suarez. We think that he might convict him of life in prison as well. Is there any chance that a judge could look at that jury recommendation for life without the possibility of parole and alter it in any which way?
So in Florida, you can sentencing is always up to the judge. However, in this particular case, because of the capital punishment, life without the possibility of parole is the only option for him.
Okay, makes sense. Makes sense moving forward. We'll have to see what happens on January 19th. If he also, I mean, it's just a formality, because if he gets life for also, you know, Yesenia Suarez, it's more of a precursor. Okay, let's talk about Adam Matos. Okay, we have this case out of Florida. This guy has killed his, well, excuse me, has been accused of killing his ex-girlfriend, her parents, and her new boyfriend at the time. This is a case of an ex-boyfriend nightmare. I want to ask your opinion. The defense has chosen not to start with their opening statements. They chose to reserve their opening statements until after the prosecution closes their case, and they feel that once the prosecution finishes their case, they said, we decide to use our opening statements if we decide to put on our own case or not. What I haven't seen that so far. What kind of strategic move is that?
Well, in many cases, a very smart move, because you need to determine what the evidence is really going to show, because there may be multiple theories for a case, right? If you want to prove or show that your client is innocent, or in a better phrase, you want to show that the state hasn't proven their case, you need factors to say why they haven't proven their case. And it's much easier to do that after the state has put up all of their witnesses. You can focus in on the holes and the things that they have not covered during their direct examination of their witnesses. If you go up first and you have this big story, because jurors want to hear a story. They don't want to hear, well, what you're not going to see is this. They want to understand from the defendant's side what actually did happen. But how do you tell that story if you're not sure exactly what the state is going to be able to prove in their case in chief? And so it is actually a very smart strategic move. If I were a defense attorney in a case where I knew I had a lot of holes to fill, where I knew I wasn't quite certain what my theory of the case is going to be because there's so many moving parts, I would likely do the same.
LaDawn, you make a great point, because if anybody was listening to the prosecution's opening arguments, really strong case. I mean, really strong theory. And if they can back that up with proper evidence and testimony, it's looking pretty strong. But however, as you said, if the defense goes forward and they start nitpicking at that testimony, well, is that really what you saw? Or the evidence, well, maybe it wasn't tested the right way. It starts poking holes in it, because the interesting part about this case is the events leading up to it. We were under the impression that the defense was going to go with a theory that someone else committed this crime, in the sense that there was a theory that there was a woman who was stalking Megan Brown, and that this woman was the one who was responsible for it. And I have to tell you, going into this case, when I thought the defense was going to put on an opening, I thought they were going to bring in something about this mysterious woman. Her name in court documents is Michelle Stinson. She's denied any involvement, but can that option still be brought out later in the case if they realize, you know what, they might not be poking enough holes in the prosecution's theory? Let's start throwing out that other suspect.
Absolutely. And then also another reason to do it is because, you know, if the defense focuses on that in their opening, then throughout the questioning of their witnesses, they're going to spend a lot of time debunking what the defense said they would be able to present. By not presenting that in the opening, they may cover it a little bit, but now the defense can really hammer it home and say, but what did they not show you? And did they can ask vague questions like, well, did you do any investigation into this issue? And they'll be able to show that to the jury during their opening portion, that there was a lot that the state was missing. They don't want to show their hand, basically.
LaDawn, you're a criminal defense attorney. I'm going to put you on the spot a little bit here. Let's say the prosecution does do a pretty good job of establishing some parts of their case. How do you explain away, for the jury, how do you explain away that Mr. Matos, well, I mean, I'm just giving now a brief part of this case. He said the last time he visited that Brown's house was the morning of August 28th, which is the day that we believe all four were killed. That was the last time he was there in the morning, which is contradictory to what the evidence and some testimony we're going to see put forth, that people saw him in the house, was ordering pizza to the house, was selling their goods from the house. He was cleaning outside of the house. He was putting trash outside of the house. So how would you explain how do you explain the fact just that he was not being truthful about when he was at the house?
So some of the things that I would focus on is probably, why would someone stay at the house if they know they've committed a crime? I will focus on the common sense of it all. If he really committed this crime, he would not have put electronic evidence out in the world showing that he was selling their dogs and doing things of that sort. I will focus on, it is a common sense argument that clearly he could not have been involved, because if he was, he would not have done all these things to leave a trail behind himself. I would also focus in on, what did these people really see? How close were they? How were they able to identify who he was? Maybe that means that there was someone else there, and try to muddy the waters that, in fact, there was someone who was involved. Had these murders occurred beforehand, he would not have been seen there cleaning up. He would have ran away like he did later on, much earlier in the case, and just try to poke some holes and make a jury think, well, that does make sense. If I did kill someone, I would run away immediately. I wouldn't stay around cleaning up and buying pizza and doing things of that sort, and hope that a jury would lean into that and want to dig further into the other dude did it defense, is what I call it, that maybe someone else was involved.
Couldn't the prosecution just say he's an idiot?
Yes, and they probably will.
He's an idiot. This is a guy, because, I mean, here's the thing, okay? We know the things that caught my attention most from the opening was, you know, the countless pizza delivery trips to the house. The fact that he went to a store and went directly to the gardening section to buy a shovel. The fact that, you know, the house reeked. It had this strong sensation of decomposed bodies, and he was going back and forth. So, you know, have you seen cases like this where at the beginning, from my perspective, from people who are watching the case, it seems like a strong case against Mr. Matos, but if the defense does some sort of legal maneuvering, they can you know, they maybe convince some of those jurors that this is not the guy who did it.
That's true. So in my time as a prosecutor, the most often that we would see cases like this that seem like a guaranteed winner is when the person said, I have nothing to lose, right?
Yeah.
I'm likely going to be found guilty.
I agree.
I'm likely to go to jail for the rest of my life, particularly in our criminal justice system where we do provide public defenders. So that means he's not spending hundreds of thousands of dollars on a legal defense team. What does he have to lose by going to trial, despite the fact that the evidence is against him, and what he has to gain if there is one juror that
that's it. You just need that one juror, LaDawn, and then they might be able to do it.
So I think that, I mean, the evidence is overwhelming in this case, and that's likely the theory that he's going with.
Yeah, well, we'll have to see. LaDawn B. Jones, thank you so much for joining us right now. We do have our live coverage in the Adam Matos case. Hopefully you can stick around, and when we have a break, we can turn back to our analysis of this case. But thank you for your analysis in this morning before we start.
Thank you.
Thank you. Okay, so we do have our live coverage in the Adam Matos case out of Florida. Let's turn to it right now.
Brian.